Hi everyone, Dexter here. Today we're going to talk about cadastral and land registration cases in consonance with Presidential Decree number 1529, the 43-year-old decree which took effect in 1978, otherwise known as Property Registration Decree. This video tutorial is requested by Attorney Vabraan Varias de Mayuga of RTC Tagaytay City and Attorney Janice Ivy Vichua of RTC Dapa, Surigao del Norte. So in this video, we're going to enumerate all cadastral and land registration cases provided by the PD 1529. So this PD 1529 dated June 11, 1978 was approved by the late President Ferdinand E. Marcos. So the purpose of the PD 1529 first is to update the Land Registration Act and to codify the various laws relative to registration of property in order to facilitate effective implementation of said laws. Second purpose, to strengthen the torrent system by adopting safeguards provided by this law to prevent anomalous titling of real property and to streamline and simplify registration proceedings and issuance of certificates of title. The last one, to hasten the implementation of the land reform program of the country, which form an integral part of the property registration laws relative to the registration of certificates of land transfer and emancipation patents issued pursuant to Presidential Decree number 27. So first from the list is the application for registrations or petition for registration of the land or application for registration of title to land. So under Section 14 of Presidential Decree number 1529, so series of 1978, Section 14 provides who may apply. The following persons may apply in the proper court of first instance. So the old name for the regional trial court. An application for registration of title to land, whether personally or through their duly authorized representatives. So first, those who by themselves or through their predecessors in interest have been in open, continuous, exclusive, and notorious possession and occupation of alienable and disposable lands of the public domain under a bona fide claim of ownership since June 12, 1945 or earlier. Second, those who have acquired ownership of private lands by prescription under the provision of existing laws. Third, those who have acquired ownership of private lands or abandoned riverbeds by right of accession or accretion under the existing laws. And fourth, last one, those who have acquired ownership of land in any other manner provided by law. So this is the first cadastral case. Okay, the application for registration. Okay. Then next case, petition for review of the registration. So petition for review of the registration under Section 32 of Presidential Decree number 1529. Section 32 provides a review of decree of registration, innocent purchaser for value. The decree of registration shall not be reopened or revised by reason of absence, minority, or other disability of any person adversely affected thereby, nor by any proceeding in any court for reversing judgments, subject, however, to the right of any person, including the government and the branches thereof, deprived of land or of any estate or interest therein by such adjudication or confirmation of title obtained by actual fraud, to file in the proper court of first instance a petition for reopening and review of the decree of registration not later than 1 year from and after the date of the entry of such decree of registration. So underline yung not later than 1 year. Should not be more than 1 year if you want to review the registration of the property. But in no case shall such petition be entertained by the court where an innocent purchaser for value has acquired the land or an interest therein whose rights may be prejudiced. So, whenever the phrase innocent purchaser for value or an equivalent phrase occurs in this decree, it shall be deemed to include an innocent lessee, mortgagee, or other encumbrancer for value. Okay? So, the third case, cadastral case, petition for registration for public interest. So, Section 36 of Presidential Decree 1529 provides that petition for registration when the lands have been surveyed or platted, the Director of Lands, represented by the Solicitor General, shall institute original registration proceedings by filing the necessary petition in the Court of First Instance of the place where the land is situated against the holders, claimants, possessors, or occupants of such lands, or any part thereof, stating in substance that public interest requires that the title to such lands be settled and adjudicated, and praying that such titles be so settled and adjudicated. So, involving public properties. The fourth cadastral case, petition for cancellation of adverse claim. Section 70 of Presidential Decree number 1529 provides that adverse claim, whoever claims any part or interest in registered lands adverse to the registered owner, make a statement in writing setting forth fully his alleged right or interest, and how or under whom acquired, a reference to the number of the certificate of title of the registered owner, the name of the registered owner, and a description of the land in which the right or interest is claimed. So that's how adverse claim can be filed, only in a form of statement. It shall be filed only before the Register of Deeds. Okay? This statement shall be entitled to registration as an adverse claim on the certificate of title. The adverse claim shall be effective for a period of 30 days from the date of registration. So, after the lapse of said period, the annotation of adverse claim may be cancelled upon filing of a verified petition, therefore, by the party in interest. Provided, however, that after cancellation, no second adverse claim based on the same ground shall be registered by the claimant. And before the lapse of 30 days aforesaid, any party in interest may file a petition in the Court of First Instance, where the land is situated, for the cancellation of the adverse claim. And the court shall grant a speedy hearing upon the question of the validity of such adverse claim, and shall render judgment as may be just and equitable. If the adverse claim is adjudged to be invalid, the registration thereof shall be ordered cancelled. If in any case the court, after notice and hearing, shall find that the adverse claim thus registered for frivolous, it may fine the claimant in an amount not less than 1,000 pesos nor more than 5,000 pesos in its discretion. Before the lapse of 30 days, the claimant may withdraw his adverse claim by filing with the Register of Deeds a sworn petition to that effect. Okay, so adverse claim may be filed by whoever claims any part of interest in the registered land in a form of statement to be filed in the Register of Deeds. Okay, the adverse claim will last for 30 days and it's not automatically cancelled after the period of 30 days. So the registered owner is required to file a verified petition, or the party in interest, a verified petition, the regular court. Party in interest need not to wait the expiration of 30 days. So he or she can file the verified petition to cancel this adverse claim. Okay. So the next cadastral case, petition for amendment and alteration of certificate. So Section 108 of Presidential Decree number 1529 provides amendment and alteration of certificate. No erasure, alteration, or amendment shall be made upon the registration book after the entry of a certificate of title or of a memorandum thereon, and the attestation of the same be registered of deeds, except by order of the proper court of first instance. To petition for amendment and alteration of certificate. So, in case there is an error in the technical description of the certificate of title, and the same is already recorded in the registration book, so the registered owner or the party in interest should petition the court to order the Register of Deeds to enter correction. Next, cadastral case, petition for issuance of a new owner's duplicate copy of original certificate of title. Okay, Section 109 of Presidential Decree 1529 provides notice and replacement of lost duplicate certificate. In case of loss or theft of an owner's duplicate certificate of title, due notice under oath shall be sent by the owner or by someone in his behalf to the Register of Deeds of the province or city where the land lies as soon as the loss or theft is discovered. If a duplicate certificate is lost or destroyed or cannot be produced by a person applying for the entry of a new certificate to him or for the registration of any instrument, a sworn statement of the fact of such loss or destruction may be filed with the registered owner or other person in interest and registered. Okay, so petition for issuance of a new owner's duplicate copy. So in case your duplicate certificate of title is lost, you need to petition the court to order the Register of Deeds to issue a new duplicate of owner's copy. But before filing this petition, you need to file first an affidavit of loss to the Register of Deeds. Next, cadastral case. So, petition for reconstitution of lost title. Under Section 110 of Presidential Decree number 1529, so provides that reconstitution of lost or destroyed original of torrents title, original copies of certificates of title lost or destroyed in the offices of Register of Deeds, as well as liens and encumbrances affecting the lands covered by such titles shall be reconstituted judicially in accordance with the procedure prescribed in Republic Act number 26, insofar as not inconsistent with this decree. So the procedure relative to administrative reconstitution of lost or destroyed certificate prescribed in said act is hereby abrogated. So there's no administrative reconstitution. So there's no administrative reconstitution of lost or destroyed certificate. So it should be done through judicial proceedings. Okay. The cancellation of encumbrance. So generally, the cancellation of encumbrance is done through administrative proceedings. So it can be filed only before the Register of Deeds. But in this case, the petition for reconstitution of lost title, so the cancellation of encumbrance may be included in the reconstitution of lost title case, so pursuant to Republic Act number 26. I provided a separate video tutorial for this one who are exempt from the payment of legal fees. One of the topics there is this one, the reconstitution of lost title. If you want to know more about the reconstitution or the exemption, so this reconstitution of lost title is exempt from payment of legal fees. Why it is exempt? So you can watch first the video on this matter, the exemption, who are exempt from the payment of legal fees. So I provided the link here, so you can click this one, the question mark up here, upper right corner. So if you want to watch the video, you can go back to this topic and continue watching the cadastral cases. So notice of all hearings of the petition for judicial reconstitution shall be given to the Register of Deeds of the place where the land is situated, and to the Commissioner of Land Registration. So, may summons. So, but since this case is exempt from payment of legal fees, no summons fees to be paid. So, only STF, Reconstitution of Lost Title, and cancellation of encumbrance if there's an encumbrance. So, we go to the topic about legal fees on petitions 4. So, to summarize, we have seven cadastral cases. So, application for registration of land, review of the decree of registration represented by the Solicitor General for public interest. Number 4, cancellation of adverse claim, then amendment and alteration of certificates, issuance of new owner's duplicate copy of original certificate of title. Last, reconstitution of lost or destroyed original of torrents of title, and cancellation of encumbrance pursuant to Republic Act 26. So we have 7 cadastral cases. Okay, so how we're going to compute the legal fee. So before that, we have to know about the BP 129. So it affects the collection of fees for the cadastral cases. Okay, so Batas Pambansa Bilang 129. So, was approved on August 14, 1981. Section 34 provides delegated jurisdiction in cadastral and land registration cases. Metropolitan trial courts, municipal trial courts, and municipal circuit trial courts may be assigned by the Supreme Court to hear and determine cadastral or land registration cases covering lots where there is no controversy or opposition, or contested lots, the value of which does not exceed 20,000 pesos. So before, the jurisdictional amount is 20,000 pesos only. Such value to be ascertained by the affidavit of the claimant or by agreement of the respective claimants if there are more than one, or from the corresponding tax declaration of the real property. So their decision in these cases shall be appealable in the same manner as decisions of the regional trial courts. So before, there is an option. So if there is no available tax deck of the land, so the party should provide the value of the property. So that was before. So now, most of the properties have records in the assessor's office, so they can provide us the assessed value of the property to determine the jurisdiction of the cadastral case. So the value is the assessed value of the property reflected in the tax declaration of the subject lot. So such value to be ascertained by the affidavit of the claimant is being used for properties without record in the assessor's office. Okay, so clear tayo dyan. For the implementation of the Batas Pambansa 129, there was an amendment to this provision. So under Republic Act number 7691. Okay, so approved on March 25, 1994. And under Section 4 of this RA 7691, so it amended Section 34 of BP 129 to read as follows. Now, the provision of BP 129 should be read as follows. So, Section 34, delegated jurisdiction in cadastral and land registration cases. Metropolitan trial courts, municipal trial courts, the municipal circuit trial courts may be assigned by the Supreme Court to hear and determine cadastral or land registration cases covering lots where there is no controversy or opposition, or contested lots where the value of which does not exceed 100,000 pesos. So they increase it from 20,000 to 100,000 pesos. And such value to be ascertained by the affidavit of the claimant or by agreement of the respective claimants if there are more than one, or from the corresponding tax declaration of the property. So, going to use the assessed value here. Again, the decisions in these cases shall be appealable in the same manner as decisions of the regional trial courts. After the 7691, we have this new RA, Republic Act 11576, so expanding the jurisdiction of lower courts. So, it took effect on August 21, 2021. Some of you thought this RA was suspended. So, because of the OCA Circular issued suspending the provision to remand cases to the first level courts, which was received by the RTC before the implementation of this RA. So the implementation, the jurisdictional amount was implemented in August 21. So it took effect on August 21, 2021. So the provision that was suspended in the implementation of RA 11576 was only the remanding of cases to the first level court. Those cases received by the RTC before August 21. So the OCA suspended that. So meaning those cases are still under the jurisdiction of the RTC. So even it less than 2 million pesos. So before August 21, 2021. Okay. To Section 1 of this RA 11576 provides that so it amended Section 19 of Batas Pambansa bilang 129. Then Section 2, it amended Section 33 of BP 129. Then Section 3 to provides a delegated authority of the Supreme Court to adjust the jurisdictional amounts of the first and second level courts. Then Section 4, the provision of this act shall apply prospectively. Section 5, separability clause. Section 6, repealing clause. So there's no mention of the amendment of Section 34, the delegated jurisdiction of cadastral and land registration cases. It means jurisdictional amount of the first level courts for cadastral and land registration cases is still 100,000 pesos and below. Okay, so more than 100,000 pesos, it's the jurisdictional amount of the RTC for cadastral and land registration cases. So the RA 11576 did not amend Section 34 of Batas Pambansa bilang 129. 100,000 and below is the jurisdictional amount for first level regular courts for cadastral and land registration cases. Okay, so we can now go to the assessment and collection of legal fees for cadastral and land registration cases. BP 129 provides the delegated jurisdiction of cadastral cases to the regular courts. The DENR requests Metropolitan and Municipal Trial Courts should hear cadastral and land registration cases also. So to unclog the cases filed before the RTCs, the Court en Banc issued a resolution, AM number 93-3-488-0, dated March 25, 1993. So the Supreme Court issued this administrative circular 6-93-A. So which stemmed from the request of DNR for Metropolitan and Municipal Trial Courts to hear cadastral and land registration cases under Section 34 of Batas Pambansa bilang 129, amended by Republic Act 7691, which took effect on April 14, 1995. Okay. This one, the provision of BP 129. So delegated jurisdiction in cadastral and land registration cases. So, Section 34, delegated jurisdiction in cadastral and land registration cases. So, Metropolitan Trial Courts, Municipal Trial Courts, and Municipal Circuit Trial Courts may be assigned by the Supreme Court to hear and determine cadastral or land registration cases covering lots where the value is no controversy or opposition, or contested lots where the value of which does not exceed 100,000 pesos. So, whether it's contested or with controversy or without controversy, so the value of the property, the assessed value, should not be more than 100,000 pesos. So that's the jurisdiction of the first level regular courts. Okay? Numerous queries were raised when this administrative circular was issued. So then the OCA clarified by issuing OCA Circular 3897 dated June 20, 1997. This circular clarified Administrative Circular number 6-93-A. So, due to numerous queries from the courts concerned received by the OCA regarding the scope of the delegated jurisdiction of METCs, MTCCs, MTCs, and MCTCs to hear and determine cadastral and land registration cases. So the first one, there are limits to the delegation. That is, either the subject matter is an uncontested lot, or if contested, the value of the lot should not exceed 100,000 pesos. Judges and court employees were confused that time about the value of the property. They thought that if it's uncontested lot, it's any amount. OCA clarified whether uncontested or contested, the amount should not exceed 100,000 pesos for the jurisdiction of the first level courts. Okay, that's the first clarification. Next clarification, to matters subsequent to the original registration determined by second level courts, including petitions for reconstitution of lost titles, so should not be unloaded to the first level courts. So the second level courts are hereby directed to take cognizance of and exercise jurisdiction over such matters. So reconstitution of lost titles is an exclusive jurisdiction of the RTC. So this is not included in the delegated jurisdiction to the first level regular courts. So if it is petitions for reconstitution of lost title, it's an exclusive jurisdiction of the RTC. Okay. Okay, to summarize, review the provisions of Presidential Decree number 1529. So we have 7 cases, cadastral and land registration cases. So this, the second column, the applicable sections of PD 1529. Okay, these are the this would be your guide. Okay, so the third column with cadastral fees. So LRA issued a prescribed fees for cadastral cases. So, but only application for registration of land has cadastral fees. So the rest, there are no cadastral fees to be collected. So regular legal fees, so the court fees only. So only application for registration of land should be collected with cadastral fees. Okay. So the next column, previous jurisdiction. So you could see, okay, the next column, jurisdiction. So I labeled it as previous jurisdiction kasi before, all these cases are under the jurisdiction of the court of first instance. So meaning the RTC. So all these cases before are the exclusive jurisdiction of RTCs. But because of the passage of BP 129 as amended by RA 7691, delegated jurisdiction of cadastral and land registration cases to the first level courts for properties with assessed value not exceeding 100,000 pesos. So it's not exclusive jurisdiction of the second level court, the RTC. So this is an old provision. The only one left for the exclusive jurisdiction of RTC is this one, the reconstitution of lost or destroyed original or torrents of title. Okay, this is for the first instance, so not applicable. So that's the sky blue column. So first column is the BP 129. So not applicable for reconstitution of lost or destroyed original of torrents of title. So same with the implementation of RA 7691. Then the third column, so Republic Act 11576, which took effect on August 21, 2021, which did not amend the provisions of Section 34. Then OCA Circular number 38, 1997 is still up to date and in effect. Okay, so again, not applicable for reconstitution of lost certificate of title. Okay, so this is the summary of the provisions we discussed earlier. Okay, using this one, the chart, you would know the fees to be collected as your guide. Here is the table or tabulation for legal fees and other collections. So I prepared 6 columns table here. The first column, we're going to enumerate 7 cadastral cases. And the next column, you would know if there is a cadastral fee for those 7 cadastral cases. The next column, filing fee for first level regular courts. The jurisdictional amount is equal to or less than 100,000 pesos. For filing fee for second level courts, this column and the jurisdictional amount for second level courts is greater than 100,000 pesos, so more pesos for second level courts. And the other fees, so what are those other fees? The LRF, MF, BCF, okay, with STF. So the first case natin, application for registration of land, so the cadastral fee, so there is a cadastral fee. So under section 111 of the PD 1529 A by LRA Circular Number 11-2002, the rates were updated on this LRA circular. For the filing fee for first level court, the basis of the computation is section 8D of Rule 141. And for second level court, the basis of the computation is section 7B1 of Rule 141. So the fee for incapable of pecuniary estimations. Other fees, LRF, MF, BCF. Okay, and with STF, yes. Okay, the next cadastral case, review of the decree of registration. So there is no cadastral fee for the review of the decree of registration. Section 111 of PD 1529 provides only cadastral fee for registration cases. Okay, so why there is no cadastral fee for review of the decree of registration? So pursuant to section 111 of 1529. Okay, so same filing fee, 8D, 7B1, LRF, MF, BCF. So yes, so the third cadastral case, so registration of unregistered lots represented by the Solicitor General for public interest. So the government is involved here. That's why it's exempt. Okay, it's the government represented by the Solicitor General who is applying for the registration of unregistered lots for public interest. No cadastral fee. Filing fee for first level is exempt for, and if it's second level jurisdiction, the other fees exempt also. So except for the STF, the Office of the Solicitor General should pay the amount for the service of court processes, the STF. Okay, that's why it's yes. The fourth cadastral case, cancellation of adverse claim. So no cadastral fee. Okay. Section 8D, so the same with the first two. Then second level, so the same with LRF, MF, BCF, and STF. So the fifth case, amendment and alteration of certificates. So same, the two for the second and fourth case. They're all the same. The sixth case, issuance of a new owner's duplicate copy of OCT. So no cadastral fee also, but with filing fee for first level or for second level. So with other fees, LRF, MF, BCF, yes. In the last case, the Reconstitution of Lost original obtorrence title, no cadastral fee. So not applicable for first level court because it's the exclusive jurisdiction of the second level court. But since pursuant to Republic Act number 26, as I mentioned, it's exempt from payment of legal fees. Okay, exempt from other fees, but with STF. It should be collected with STF for the service of court processes. Okay, here is the computation. Here is the computation for filing an application for the registration of land. So, per title, ang computation natin. So, assuming the assessed value of the property is 620,000 pesos. Okay, and one summons fee shall be issued. Okay, the basis of the filing fee for second level courts, unahin natin itong second level courts computation, is section 7B1. One as incapable of pecuniary estimation. This is the allocation, 400 for JDF, 1.6 for SAJ, so total ng 2,000 pesos plus summons fee, then total, then 20 pesos ng LRF, 20 pesos of the 1% of 2,000, so 20 pesos plus MF, BCF with LRAF, okay, cadastral fee. So the cadastral fee, the Land Registration Authority Fund or cadastral fee is 1,938. So how did we arrive at that amount? This is my computation. Okay, so following the rates prescribed by LRA Circular 11-2002. So this is the table. Okay, the 620,000, going to get it from the table. Letter E. So, section 111 AE. So, when the value of the property is more than 500,000, so for 500,000, meron na tayong 1,560. So, yung excess sa 500,000, for each additional 50,000, may 120. So, mas mura pag cadastral fees. So, yung 620, so may dalawang 50 doon. Yung 50, 600, tas may 20 pa. So, pero ang sabi dito, or fractional part thereof. Kung may sobra pa kung merong amount na sobra, kahit hindi siya 50, 120 pa rin yung value niya. Ibig sabihin, for fraction part thereof. Okay, so ang total Land Registration Authority Fund is 1,920. How did we arrive on that amount? So yung 500,000, 1,560. Okay, zoom natin. 500, then 50 is 120, 50, 120, 20 pesos, kahit 20 pesos, also 120. Okay, so total, 620,000 pesos, equivalent to 1,920 of LRAF fees. Then may 18 pesos tayo, plus 18 pesos, pursuant din yan sa section 111B2 of LRA Circular 11-2002. Ano yung B2? Yun yung service of notices. So, if in case of service of notices, may 18 pesos na i-add. So, 1,938 ang babayaran, additional na babayaran ng party for cadastral fee. Ang total niya is 5,663. Okay, so ito yung LRAF in addition dito sa other fees. So kasama na siya yung cadastral fee, kasama na siya dito sa other fees. Okay, so apat ngayon silang other fees for registration cases lang, ha. So yun lang ang may cadastral fee. Sa cadastral cases and land registration cases, yung registration ng land lang. So other cadastral cases like yung cancellation ng adverse claim, yung mga review ng certificates, amendment ng certificates, issuance ng owner's duplicates copy, walang cadastral fee. Okay. Then computation for the first level courts. So assuming na 100,000 lang yung assessed value ng property. So ang filing fee for first level courts, so section 8D. 8D natin, 700 lang yung fee doon sa Section 8D sa Rule 141. Okay, 700 para sa such lang. So, plus summons fee na 200 kung ilan yung respondents. Okay, then may cadastral fee, LRAF, na 258 lang. Kasi, fall lang siya sa number unang-una. Dito sa more than 100,000 pesos. Section 111A 1C. Sa C, na natin yung table ng LRA. So, dito siya sa C. Okay? When the value of the property is more than 10,000 pesos but does not exceed 100,000 pesos. So, 240 ang registration fee. So, plus 18 pesos again under Section 111B2 na 18 pesos per notice kung magsaserve. Posting of notices. So, nandoon yan sa Section B2 ng LRA Circular. Additional, may 258 na ba additional fee para cadastral fees. Okay? So, yung total na babayaran ng party, 2,673. Itong 2,673, ito yung fee babayaran for registration of property doon sa first level court. Yung value ng property is not more than 100,000 pesos. Okay, so from 10,000 to 100,000 pesos. So any amount from that range, ganito ang babayaran, 2,673. So pwedeng nyo tandaan yung amount na to. From 10,000, 10K to 100K. 100. Yan na yung fixed amount na yan. Pag isang respondent and isang notice, isang title, isang land. 2,673. Okay. Then for other cadastral cases, ibig sabihin, means hindi siya registration ng property. So, yung mga petition for review ng decree of registration, cancellation ng adverse claim, amendment of certificates, issuance of owner's duplicate copy. So, for second level courts, kung 620,000 yung value ng property, yun din. So, the difference doon sa registration, walang registration, Land Registration Authority Fund, walang cadastral fee. Okay? So, that's the difference of the other cases aside from registration of property. So, there is no cadastral fee to be collected for the 4 cases. Yung review, cancellation, amendment, and issuance of new owner's duplicate copy. Ito lang yan. Okay, sa Section 7B1 pa rin. For second level court, 620,000, irrelevant yan sa Rule 141 kasi fix yung 2,000. Okay. So kung sa first level court yung jurisdiction, 100,000 yung value ng property, 2,415 lang yung babayaran. So wala ring cadastral fee. So ang filing fee is Section 8D na 700. Okay, kung one respondent lang din, 2,415 kung hindi siya registration ng property. Ilang ang pag-compute ng cadastral cases. So kung reconstitution of title, walang babayaran except sa 1,000 na STF. So yan lang. Kung any value ng assessed value ng property, so ang exclusive jurisdiction yan is sa second level regular court, the RTC. So 1,000 pesos lang ang babayaran pag reconstitution of title pursuant to Republic Act No. 26. Okay, clear tayo dyan. Alright, if you want to see more videos like this one, you may consider subscribing and you can share this video to anyone. Be sure to hit the like button. Thank you. Stay safe, everyone. Bye.